I am, on this occasion, I want to visit about retribution. I believe retribution is another one of those myths of the death penalty. It is an illusion that brings support to the death penalty. Retribution is often indicated as the justification for the death penalty, and the idea is that families that have suffered such a loss ought to have their pound of flesh. They ought to take a life from the person who took that family member away from them in such a hideous manner. It is feeding an emotional need. It's feeding an emotional need. And when you look at retribution, I don't think you can look at retribution. So far, we've delivered retribution to 3 families. We have had 175 death penalty eligible defendants in this state, and we've delivered retribution to 3 families. And I don't think we can look at retribution without looking at the 172 families that didn't get it. You see, as long as we have the death penalty in Nebraska, people whose family members have been lost in a hideous manner in some senseless act like that occurred in Norfolk, the families are going to come to this institution for retribution. They'll want the death penalty for the person that killed their loved one. Out of 175 death penalty eligible homicides in the state of Nebraska, we have turned 140 of those families away. So when we talk about retribution, we should consider those families that we say, this institution is not available to you. Senator Ashford has discussed the opinion of Chief Justice Kravosha, where he outlined some of the murders that haven't put people on death row. They are some of the worst murders in the state of Nebraska. Some of the worst murders. The circumstances are as bad as anybody that's sitting on death row has done. But to those families, we've said this institution is not available to you. Maybe we did it as a prosecutor because we can't afford to prosecute one of these things. We'll bankrupt our county. 140 families had to be told, no, we're not going to bring the death penalty to your family and to this circumstance. And it is even more concerning to me that we had death penalties in 31 cases, but we've only delivered on 3. Now, if you want to talk about retribution as some sense of satisfaction for the family, and there's nothing we can do to make their pain go away, but if we could deliver something to those families, think about what we're delivering to the families who spend 20 years watching somebody go through the appeals only to be exonerated or only to have their death sentence reversed. We say to those families,
1 minute.
You have hope for the death penalty. You have hope for retribution. We only written 7% of the cases. 7% of the people we put on death ultimately are killed there. 93% of the families we say, I'm sorry. This institution failed 93 families. It failed, pardon me, it failed all the death penalty eligible families. Failed in 93% of the cases where thought they were going to get the retribution they wanted. I think the death penalty brings misery to the victim's family. Then such an institution should warrant. And for that reason, we should pass L. 76. Thank you.
Thank you, Senator. Senator Preister, followed by Senator Chambers, Senator Wallman, Senator Flood. And
it's part of my struggle in making a decision, but this morning I did make a decision, and coming in I wasn't sure how I was going to vote on select file. I did say I opposed the bracket motion because we need the discussion. But this is a good discussion. It is raising good issues, and it is addressing those issues. So I appreciate the level of that discussion. For that reason, and I think the public has a right to hear and see and be a part of this process through the media and through their direct involvement through NETV, they're getting some education on this issue. I think as serious an issue as this is, it deserves merit on at least select file. So I've made the decision, as I'm listening and going back and forth, that I want to at least continue the debate, and if that means voting in favor of 476 to continue that debate, to continually engage the public, then that's what I intend to do, and I want it to be on the record of supporting that.
Mr. I'm going to scamper through some of the things that other senators have said, because today we're kind of giving an overview and laying of the groundwork for more detailed discussion later. Senator Flood has talked in kind of dry terms about the dry aspects of the legalese associated with the death penalty. He had mentioned that the 8th Amendment to the Nebraska Constitution does not require any more in the way of protection than the U.S. Constitution. Well, some people say that since death was accepted as a punishment, when the U.S. Constitution was brought into being, it could not be considered unconstitutional if it was recognized by the Constitution. And it's explicitly mentioned in the 5th Amendment. A person shall not be put twice in jeopardy of life or limb. But what does it mean when it refers to limb? Mutilation. They mutilated people during those days. But the U.S. Supreme Court has ruled that mutilation is unconstitutional, even though it's mentioned in the Constitution. It is unconstitutional. A society is expected to grow, to mature, to become more civilized. It's kind of ironic that in the balcony we had Australians, and in their country they have no death penalty. We had visitors from North Carolina, and their enlightened court system has put all executions on hold because of the problems with lethal injection. So in both cases, they're sitting here looking, especially the Australians, saying, we're in America in the year 2007, in the country of the moral arbiter of the world, and they're arguing, some people passionately, for the right of the state to continue killing. And because America as a country approves of killing, there are other countries which will not extradite a criminal wanted by America, no matter how heinous that person's crime may have been, if he or she faces the death penalty in America. So if America wants that person extradited, there must be an assurance given that no death penalty will be inflicted. To be a member of the European Union, a country must have no death penalty. Turkey is talking about doing away with its death penalty because apparently economic considerations are leading countries to do that which no amount of moral suasion can achieve. The idea of being with the in crowd when it comes to politics and economics is leading countries to do away with the death penalty. And for my part, since I'm against it under all circumstances, whatever it takes is what I'd like to see come into play. Thank you, Mr. President.
Senator Chambers, you're in the queue to speak next.
Thank you. I will continue. Senator Flood and Senator Whiteman talked about a specific aggravator which shows the irrationality and illogic of the death penalty. They both mentioned subsection B, which makes it an aggravator to commit a murder to conceal a crime. Now, brothers and sisters, friends, enemies, and neutrals, if the underlying crime does not carry the possibility of death, why will I commit a murder and run the risk of being executed to cover up my identity for a crime that carried no possibility of dying? In other words, I'm willing to risk the death penalty to avoid going to jail for a theft. So that means I fear the death penalty? That I'm a calculator? No, it shows the irrationality of all this. Senator Flood mentioned that the death penalty should be used for murderers for hire. The two who were on Nebraska's death row allegedly for murder as murderers for hire were taken off death row because the sentencing panel was not unanimous. So the murderers for hire are not on death row. At the federal level, anybody who has followed these things knows that the murder for hire is a practice, a modus operandi of organized crime. But you have not, and you cannot show me an example of a murderer for hire being executed by this government. They become snitches. In exchange for snitching, they don't face the death penalty, and they are given an identity in the witness protection program. And those that don't have to become snitches have such high-powered lawyers and have connections that avoid the death penalty for them. No rich person has ever suffered death in this country, in the history of this country. Senator Avery mentioned two things that are constant in this discussion: economic status and race. And as long as you have people motivated and influenced by those factors, you're going to have a hippity-hoppity kind of penalty. Where the rich are concerned, never a death penalty. The poor cannot hire good lawyers. Kenneth Starr, who used to be the special prosecutor, talked about the problems with the death penalty, and he said adequate counsel is a problem. The large firms which could provide such counsel are not going to do it because it requires giving up too many tens of thousands of dollars. So he's acknowledging that there are people deprived of an adequate defense because they don't have the money. And when lawyers are appointed to offend people on trial for their life, a woefully small amount of money is given. No money for experts. No money for investigators. And yet this society, which says it has a philosophy of life, is going to make it almost a cinch that the person on trial for his or her life, and who is a member of a despised class anyway, and is facing prejudice, is not going to have adequate representation. How can a society which prides itself on principles of justice being the guiding lights going to be aware that people's lives are taken while they're being defended by lawyers who come to court certifiably drunk, who sleep during the trial, and these things have been established on the record. And appellate courts have said that is not enough basis to establish inadequate counsel for the purpose of overturning a death sentence. So I've got a lawyer sleeping off a drunk, and it's clear in the courtroom, and I can be sentenced to die. But I might be one of those lucky people where DNA will show that I could not have been the killer. Then what do people say? That proves the system worked. No, it proves that the system was robbed of its prey. If the system worked, we wouldn't have innocent people being convicted and sentenced to die. We wouldn't have people being represented by attorneys appointed by the court when the court knows that attorney might be fresh out of law school, has never defended a capital case in his or her life. So in that area of the law, where the U.S. Supreme Court, the appellate courts, have said that more time and care should be given. Thank you, Mr. President.
Thank you, Senator Chambers.
Thank you, Mr. President, members of the body. I find it very interesting who gets executed. It's usually by never a hired attorney. If you hire an attorney, how many people get executed? Not too many. Public attorneys, or you hire public attorneys, or they're furnished for you, you're probably not going to have a good chance. And we talk about retribution. You know, vengeance is mine, says the Lord. If we're going to look, one constituent called me up, it says in the Bible, eye for an eye, tooth for a tooth. But it also says, vengeance is mine. And so what are we? And if we're going to make a decision here about the death penalty, I'm against this bracket motion. I think we better make a decision. And the year of our Lord 2007 might be a good year to do it. And we're talking about people's lives. And I know of 2 people that have had murdered in their families. Did they seek the death penalty? No. And that spoke volumes to me. I guess if Tom, you're gonna murder my wife, I might murder you. But I could not push a button for somebody else. I couldn't do it, you know, and but I probably could for my own family. And so I'm taught, you know, we're taught to strike back. That's a farmer's way. That's a military way. Strike when in the iron, do it right away, take care of the problem. But the legislature is supposed to take care of this problem here, the death penalty. I didn't want to talk on this. It's very emotional for me. But when you know families that it happened to and they don't seek the death penalty, what does that tell us? I guess if you want to press the button, if any one of us in here want to press the button, that's okay. I'm not going to say which way you should go. But I return the rest of my time to Senator Chambers.
Senator Chambers, about 3 minutes.
Thank you, Mr. President. Thank you, Senator Wallman. And since the subject of retribution has been raised, I think I'll touch on it also. That notion of an eye for an eye and a tooth for a tooth comes from the Bible, the Old Testament. It's not something God said, but it's interesting that the Hebrews, the Jews, who are supposed to be the ones who brought us that law, never enforced eye for eye, tooth for tooth. And you know what their rabbis said? If Mr. A takes the eye of Mr. B, how do we know that if Mr. B takes Mr. A's eye, that Mr. A's eye does not have greater acuity? There is no way to determine that the eye being taken was precisely the same as the eye that was lost in the first instance. Therefore, no person can take the eye of another simply because his or her eye was taken. Instead, that became a measure of damages. How much value is that eye to the person? How much harm is endured as a result of losing that eye? They never said, if I broke Senator Carlson's tooth, that they would hold my mouth open and allow him to break my tooth. It was a measure of damages and never to be taken literally. And it's interesting to me how the literalists, when it comes to the Bible, are literal when it comes to cruelty, harm, and hurting others. But when it comes to the kindness, the compassion, the mercy, and Jesus was known as the one who brought mercy, that is laid aside. And they say, but there's something above that. Eye for eye, tooth for tooth. And that never was imposed. And when it came to the death penalty itself, they had a multi-member court.
1 minute.
The Jews did. And if a unanimous decision came down, there was no death penalty inflicted. And do you know why? The reasoning was this. No man, when he is facing death, should come to a situation where everybody feels that he has no argument in his favor. Somebody ought to see where there was a mitigating factor for that man. And since there was no person on this court, the death penalty cannot be carried out. If you want to study history, study it. You mention these things, but you don't know their history and how they were applied. When they were taking a person actually to the stoning, a herald or a person who spoke had to precede the entourage and cry out, is there anybody who can say a word for this condemned? Anybody? Is there anybody? And if somebody said, I can, that stopped the proceedings right there. Every means of preventing the carrying out of a death sentence was resorted to. Thank you, Mr. President.
Thank you.
What we intend to accomplish with our criminal law code in this state, and really the intent of criminal sanctions in this country. And for me, it boils down to 4 main objectives: public safety, retribution, rehabilitation, and deterrence. Public safety, retribution, rehabilitation, and deterrence. And I want to confront the issue of retribution head on. I know that some of you hear that and say, well, wait a second, that's exactly what drives me to support LB 476. And for that, I cannot pull you back if that's your position. But how is retribution in this level for these crimes different than the retribution that is advertised for drunk drivers. Do this and you go to jail. Think about what you see on TV. You drive drunk, you go to jail. We're going to get you. We're going to make you pay for the crime. You sell drugs in this state, it's a Class 2 felony, you could spend up to 50 years in prison. 20 years is a common sentence. How is that not retribution? So as we connect the dots today, there should be no visceral reaction to retribution as one of the components or considerations of the criminal law when it reaches the first-degree murder offense. The second thing I want to talk about, and Senator Chambers raised this point, was that in Section 292523 sub 1b, the murder was committed in an effort to conceal the commission of a crime or to conceal the identity of the perpetrator of such crime. As an officer of the court, Senator Whiteman is as well, if I had to justify that without reading any law review articles or reading the testimony, I would say that aggravator exists to protect the administration of justice. You cannot go and kill somebody to prevent them from testifying against you or to conceal your crime. It's crime on top of crime on top of crime. And I think it's justified. The next thing I want to talk about, and as long as we are talking about aggravators, that aggravator that I continue to raise at Section 1D, the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. It sickens me to even have to talk about this, but sometimes you have to connect the facts to the crime to show you what a district court in the Panhandle identified as meeting the standard that I just acknowledged in Section 1D of Section 292523. And that's in the case of Raymond Mata. The basic facts of Mr. Mata's case: he abducted and murdered a 3-year-old child of a woman with whom he had had an on-again, off-again relationship. A search warrant is executed at his sister Monica's house where he had been residing. And from the case expert, I give you the following, quote, "Police searching for Monica's residence found human remains in the basement room occupied by Mata. Hidden in the ceiling was a package wrapped in plastic and duct tape which contained a crushed human skull. In the kitchen refrigerator of the residence, police found a foil-wrapped package of human flesh. Human remains were also found on a toilet plunger and were found to be clogging the sewer line from the residence. Human flesh, both cooked and raw, found in the dog food bowl/bag of dog food. Human bone fragments were received from the dog's digestive tract." By every account, I can understand
1 minute.
why the court found that this murder, in Mr. Mata's case, met the standard of the aggravator found in Section 292523 1D, that the murder was especially heinous, atrocious, cruel, or manifested exceptional depravity by ordinary standards of morality and intelligence. The 3-judge panel found one statutory aggravator, and the one I just read to you is it. The 3-judge panel found no statutory mitigators, but considered 4 non-statutory mitigators, and Mr. Mata was sentenced to die. The Supreme Court remanded this case for resentencing, and again he was sentenced to death. This Supreme Court ruling is now pending on appeal. It makes a difference, I think, when you look at the conduct we're talking about here. I cannot speak for the over 150 cases that Senator Lathrop raised. But the parting comment I want to make is in regard to Senator Wallman's assertion that for some reason a court-appointed lawyer is different than a private pay lawyer.
Time, Senator.
Thank you, Mr. President.
It's been mentioned several times that the death penalty does not deter crime. And in my 15 years on the Judiciary Committee, I've read enough information and heard enough information that I believe it does not deter crime. If it does not deter crime, then I see it that we are not necessarily saving lives in the future by having laws like this, but instead we are taking lives under the auspices of the law. And Senator Flood mentions the courts have done a good job. Yes, they have. Yes, they have. But the court's court's job is to follow the law. And we here in this room make that law. We're here today to look at changing that law so we do not condone capital punishment in the great state of Nebraska. 14 years ago, when this death penalty came to the Judiciary Committee, my first year on the committee, we stayed here late in the evening hearing testimony against it, in favor of the death penalty. We had emails and mail in my office that overshadowed everything else in that session. Here we are, people, 15 years later, and there was nobody showed up to testify against this bill. People have changed their minds. Compassion for life, I think, has taken over. We've got a few emails and some letters in my office, about half and half for or against LB 476. I remember those years when the death penalty was carried out, of the people carrying the banners, hollering, "Fry 'em." And some of them same people who I knew were in church the next morning holding hands, saying, "Forgive us our trespasses as we forgive those who trespass against us." And that doesn't say for stealing a dime or a nickel. That are his words about forgiveness. And it says nothing about condoning the sin. I don't condone murder. I don't condone pedophilia or any of them things that people do time for. But I, as a sinner, realize that there must be compassion. And we can give that today and still have a safe society without putting these people to death. Again, we in this room make the law.
1 minute.
The judge's job is to follow the law, and they've done a good job of that. Some of us are at the end of our political careers. I'll be done here next year. And I hope that I can go to bed those nights after I'm through with the legislature saying that I did not make political decisions about life and death. Thank you.
Thank you, Mr. President. Thank you, Senator Shimmick. And for Senator Avery and others who've expressed some misgivings about the inequality that is found when the death penalty is involved, look in the Bible again. And Senator Carlson, I pronounced it that way in deference to you. And if I remember, that's what I will do, but habits are hard to break. Take the example of Jesus and Barabbas. Barabbas was a man convicted of riot, insurrection, and murder. Jesus, by all accounts, even Pilate, was innocent. Which one did the mob who was inflamed against Jesus, which one did they say should go free? The innocent man or the murderer? The bad one. He's the one who got away. Go out and look in the yard in the penitentiary, and you will see men who committed far more heinous crimes than even those described by Senator Flood. And they did not face the death penalty. They either were not charged with first-degree murder or charged and allowed a plea bargain. What happened to the innocent man? Had I been a Roman senator, perhaps there would not have been a death penalty, and Jesus would not have died. And we wouldn't be here talking about the death penalty because there would not be Christians trying to hold on to it. But be that as it may, let me continue on a different track. Senator Whiteman had said that even if we had a life sentence and we'd have all these appeals, all you need to do is look at the circumstance, not only in Nebraska but around the country. There are not that many appeals. Courts have put in place a special system for handling death cases, and that system applies to no other cases. It is not happening now in life cases. It is not going to happen. And Senator Whiteman, I think, was sincere when he said it, but he was simply mistaken. On the retribution, again, Senator Flood kind of veered off the track. He mentioned the retribution, you can call it that, for somebody who drives drunk. That is not final. The retribution does not extend to taking a person's life. And Senator Flood knows that there are lawyers and others who will have a third offense or fourth offense or fifth offense, drunk driving charge, reduced to a second offense. Check the case of a lawyer in Omaha named Willow Head and see how the courts have dealt with her if you want to see even in a situation that doesn't involve death, where for some reason courts favor some people and skew the law. But in this particular case, something similar to what Senator Flood talked about was something like a sex triangle, Senator Flood, and the last name of the family was Noakes, or Nokes, N-O-K-E-S. The wife and husband murdered this person, dismembered the body, wrapped the parts in butcher's paper, and threw them in the reservoir. They did not even face the possibility of a death sentence. And they're probably out now. So when these emotional appeals are made, we can all respond to them emotionally. And nothing's wrong with that. And Senator Wallman spoke for a lot of us, if not all. If something was done to somebody very dear to me, and under the heat of the emotional upsetness I would feel, maybe I would do a terrible thing to that person if I could get my hands on him. But I have a direct connection to the victim. My emotions are inflamed. I would acknowledge that I am not thinking at that time as I am now. And I'm carried away, and I do something which I may regret. But people would understand that, and when you act under those kind of emotions, you may not even be held criminally culpable. You may get off. But we're talking about the settled, deliberate policy of a state, not acting supposedly under inflamed emotions, not even knowing or having any direct connection to a victim 20 or 30 years after the event, coldly, calculatingly require some of its employees to kill a person they don't even know, and from having served on a death watch may have bonded and feel that this is horrible and wrong, but it's my job, as said the Nazis. And the Nazis, by the way, are the ones who created lethal injection. Thank you, Mr. President.
Senator Lathrop said, something Senator Flood said. Those questions, when Senator Lathrop talked about retribution, Senator Flood talked about aggravating circumstances. I would submit to you, if a family member is violently taken from you before their time, are you any less hurt, any less pain if there were no aggravators present during that death? I suggest not. And as far as retribution, are you going to expect any less retribution if those aggravators aren't present? I suspect not. For those reasons, I'm questioning myself, where is the consistency in our punishment system? I'm having a hard time right now trying to figure that out, and I'm struggling with that decision.
Thank you, Mr. President. Thank you, Senator Aguilar. And to Senator Avery, who raised the very important issue of the impact of race. And somebody else then mentioned, if it was not Senator Avery, that the race of the victim is what really tips the scale. And if the victim is white, then there's a greater likelihood of a death sentence regardless of the race of the perpetrator. So if it is my life, society does not place the same value on it if that's what we're talking about. It shows once again that I'm put in a subhuman category. And maybe I can identify Senator Carlson with the comment about Jesus when they were mentioning the 30 pieces of silver. This is how they valued him. So that's how they value my life. But I had mentioned something that Kenneth Starr had said. I want to read the quote. It's from the San Francisco Chronicle of February 17, 2006. Kenneth Starr, former U.S. Special Prosecutor and current Dean of Pepperdine Law School, quote, "Society is not equipped to handle death penalty cases because of resources. Large law firms are not willing at this stage to take these cases on at a cost of many thousands of dollars in order to make sure that if the public wants the death penalty, it is not administered with arbitrariness and caprice." Here's a comment from a former Texas prosecutor. The county was Bexar, Bexar County, Texas. I've come to the conclusion, his name is Samuel Millsap, M-I-L-S-A-P. I've come to the conclusion that the system as it relates to capital murder is simply broken. It's my view, in fact, that because it's driven by human beings and decisions that are made by human beings, it cannot be fixed, and that as a result, what has to happen is that the option to put people to death has to end. And that, he said, July 21st, 2006, and he was a prosecutor who had sought death sentences. This system never was right. It's wrong now. It always will be wrong, no matter how they try to prettify it or give the taking of the life the appearance of a medical procedure in a well-lighted, sterile hospital room. The fact is, you cannot make dung honey by dressing it up any kind of way. We need to focus on the wrongfulness of the state killing.
1 minute.
And at some point, I will point out how it started really gaining momentum with Pope John II. The Catholic Church's reassessment of its teaching on the death penalty, and how in these days, in these developed countries, there's no justification for the death penalty because the person who committed the crime can be put in a place where no harm can be done to others. You have a right to defend yourself, but when the one who is going to do harm can no longer do harm, the infliction of death is never justified under those circumstances, and I will read the direct language to that effect. But again, today we're just kind of doing an overview. Thank you, Mr. President.
Mr. President and members of the legislature, in keeping with the overview tone, I will yield my time to Senator Flood, as I'm sure we'll have more discussion tomorrow. Senator Flood.
Senator Flood.
Thank you, Senator Erdman, for yielding me your time. I guess I want to get back on track here with regard to some of the due process and constitutional discussions that we've already had, but I want to readdress a point that Senator Wallman made some time ago. Senator, you stated that court-appointed counsel was somehow less effective than paid-for lawyers by the defendant. Now, I think that is an overgeneralization that may in some instances be true based on what counties pay. But I can tell you from my own experience in Madison County, I think defense counsel, especially local counsel, has done a good job of defending defendants in this type of a case, in this situation. So I don't really have a violent reaction to your statement, but I do have an objection to making a generalized statement that for whatever reason a court-appointed lawyer is somehow less capable than a lawyer paid for by defendants' funds or friends of the defendants' funds. And with regard to Senator Chambers' comment about my discussion regarding drunk driving or drug offenses, I don't want to minimize the death penalty discussion by drawing lines back and forth between Class W misdemeanors or Class 2 felonies. And that was not my intention. My intention was to show that retribution exists throughout our criminal code in the penalty phase for defendants. But I recognize the stark difference between a first-degree murder case where the penalty is the discontinuation of an offender's life, killing an offender, compared to the 90-day revocation that may be found in a Class W misdemeanor first offense. And in no way do I think the two are remotely similar. Tomorrow, we're going to have a discussion on my next amendment that basically removes the super due process provisions that LB 1 in 2002 and work the legislature did in 1999 and prior have in our statutes for the commission of a first-degree murder. If the policy of the state is going to be not to execute individuals, then I do not see why we need the extra hurdle of due process in our system. And that's what my amendment's about. It doesn't mean I'm going to vote for the bill if it's adopted. You may say it would make, from my vantage point, a bad bill better, but not follow with my vote in support of the same. So that's what's coming tomorrow, and I think that talking about the super due process protections will also give us a chance to painstakingly review the aggravators, the mitigators, the extra hurdles for the prosecutor, the protections already built into the system. And as Senator Chambers shared a story where the accused was walking through the community or the city in the Roman times, and everybody had the chance to wave their hand and say any reason why that offender should not be put to death or their situation mitigated. I think if you look at the law, we have significant protections built into the same. And I'm also hopefully going to address tomorrow this idea that to make the death penalty more effective, we should be killing more people on death row. And at the same time, there's this argument that it takes too long and it costs too much money. You can't have it both ways. You can't, as a proponent of 476, talk about not doing it enough and at the same time talk about the costs. I believe that our system is set up to do everything possible under the law to examine whether or not the defendant or the accused or the offender, you shall say, warrants receiving the death penalty. And did the offender receive a fair trial? Those are the considerations that I think face us tomorrow. I want to thank the body this morning for what I think has been a very thoughtful, high-level debate on issues surrounding LB 476. And with that, Mr. President, in advance of tomorrow, I hereby withdraw my bracket motion currently under consideration.
Thank you, Senator Flood. Senator Flood withdraws his motion to bracket. Before the body is, shall the legislature adjourn until Tuesday, March 20th, 2007 at 9 a.m. All those in favor say aye. Opposed, nay. We are adjourned.